Well, what happened this morning was we walked in the court. We had not, to this point in time, been served with any papers by the other side, and they presented us with unbound affidavits, memorandum of law, which are really contrary to procedure under CPLR. We asked the judge for a default on the basis that they hadn't served us, and they've had the papers for 2 weeks. They've had our papers for over 2 weeks, and the judge refused to do that. He said, I'm going to give you some time to look this over, and we said, well, we don't think this is going to be enough time, and that since this was brought on by themselves, we would like you to revisit the temporary restraining order that you denied. So, well, if you wanted to revisit that, you should have appealed it. I said, well, we weren't going to appeal it based on that. We want to revisit it based on the fact that we need time to respond, and they defaulted. And he said he wouldn't hear that. So he said he would give us time.
Let me just ask that the TRO hearing, wasn't the issue of notice like a paramount issue for the judge?
Well, yeah, the issue was for the TRO. He said, he didn't want to argue at ex parte, and they needed time to be able to reply, and they needed time for it. So that's why it was set for 2 weeks later. And so that this time didn't seem to be an issue. He said he was going to read it, and we needed time, and he would give us time to read it. And I noted that his reading it is one thing. Our reading is we need time to respond to it. And so he said, go read it. So we went out. We were outside for about maybe 7 or 8 minutes. First, just trying to divide up how many different affidavits were, because they weren't bound, and we had just begun to look at it, divided up between 3 of us, had just begun to look at it, and we got a call to come back in the courtroom. And the judge then asked us to argue. And I said, I can't argue, I can't respond to those papers. You haven't even had time to even really look at them. And basically just reiterated the arguments we had made before around the fact that this whole process was just bankrupt in the number of folks who had not gotten their ballots and the folks who had gotten ballots who didn't deserve it, and that the so-called rectification process was suspect because the person appointed to do that was not an expert in that area, and just as importantly was a partisan in the election. And that also the question of the non-recognition of the USOC, the unpaid staff organizing. So he made a point around asking about whether there was a contract between Pacifica and the unpaid staff, whether it had a date on it, an end date, and I pointed out, no, it had no end date, but that Pacifica had always recognized that, and up until this present management was installed in spring of this year, every general manager had recognized the USOC, so that should not be an issue. So he said, okay, thank you. You're getting back into issues that and they said, well, there was only 2 affidavits where people alleged that they hadn't received the ballots. I said, yeah, but I have a number of emails of people who up until last week still had not received ballots, and I read to him a letter from Eddie Ellis where he talked about he had requested 4 times and still had not received a ballot. I said, well, thank you. And he had a jury coming in for a trial, and he would get back to us hopefully this afternoon with a decision.
So on the question, this is on the injunction, not on the underlying case,
on the injunction, right? Not on the underlying case.
Now, the test for an injunction on the CPLR would be normally 3, right? Irreparable harm, probability of
equities, and probability of success on the merits.
Right, and then generally they require a bond posting, but they wouldn't hear because
we never even got to that point.
Yeah, so
got to that point.
So, and then if he denies,
it was very cursory, and so.
Then if he denies the injunction,
we could
still the underlying case is going. You can appeal that first.
The underlying case hasn't been touched yet. That'll go on regardless.
The judge asked a few questions about USOC, and it seemed very clear that the judge understands that USOC was recognized, and there's no expiration date in the USOC contract. And Roger very clearly said every one of the general managers has recognized USOC all along until the current management, and those points were very clear, and I had the feeling, though you never know, that the judge was was taking that seriously. He certainly didn't say USOC is not recognized or anything summary like that, as some people were saying.
The unpaid staff organizing.
Yeah, the unpaid staff organizing committee. So, so it seems like looks like he's giving some credence to our arguments about the unpaid staff organizing committee. Then the Pacifica lawyer tried to argue that the issue about the disenfranchisement was moot because very few people had been disenfranchised. And Roger said, well, wait a minute, here's a letter from Roger Ellis, there's 5 people he talks about, and I have a bunch of letters, and he held in his hand a bunch of emails that he had and said, look, I got all of these letters from people who are saying it's not just 5 people, it's a lot of people. And these people are saying they've mailed in and called 4 or 5 times to Ethan Young, and where are our ballots? And I don't know how the judge felt about that, but to me it was a good argument. It should be taken seriously. And then the Pacifica lawyer just sort of repeated himself and said it's not that many. And what can you say? That it is a lot of people, and we know it is, and there's no way of really knowing what the quality of this election is.
Well, what I really want to talk about is Pacifica management. And I want to continue to bring up the issue that we have a thoroughly corrupted voting pool, an inequitable campaign process, and a fraudulent election, which management is advancing and advocating in every sense of the word. On top of that, what the real issue here, or another part of the issue, is the disenfranchisement of the people who make the station happen, which is the hundreds of unpaid staff who have banded together to try to have some minor impact on the conditions and terms of their work. And they formed an entity called the Unpaid Staff Organizing Committee to negotiate for their labor power, regardless of whether they're paid or not, which is in the best tradition of radical worker activity. And management is working as aggressively and difficultly and hard as it can, along with the chair of the local station board, Mitch Cohn, and the majority faction on the local station board to crush the union. And so the issues to me are not so much about litigation. That's a tactic that you utilize to try to advance what we think is absolutely unequivocally right, legally and factually. But the real issue is that the station and the network are in the hands of very reactionary people who are altering decades of progressive tradition in radio, not just the broadcast, but the way the station functions procedurally and in its response to its staff. And that is a tragedy. So of course we'll wait for the judge's decision, but one way or the other, there are many mountains to climb to take back BAI from right reaction.
I think this is just a very important case in terms of really maintaining the mission of WBAI, and that people who are listening to this or viewing this should understand that this is not simply a very petty kind of electoral issue. It's an issue in terms of which way forward for WBAI.